On the surface, the court ruling that took place about the definition of a woman is fairly straightforward. But there are troubling legal developments in this civil rights discourse in the UK, and the Supreme Court's ruling on the definition of woman within the Equality Act and the extraordinary wave of protest that it has triggered should make people pause. What what looks on paper like a judicial clarification is in fact a political act masquerading as neutrality. Worse still, it may be based on deeply partial testimony and procedural exclusion. And the legal implications are that trans women, even those with a gender recognition certificate, can be lawfully excluded from single sex spaces and services and roles when proportionate. Uh, and there's ambiguity in actually what the Supreme Court has said. This case arose from the Gender Representation on Public Boards Scotland Act 2018, which attempted to mandate 50% women's representation, and feminist groups, a feminist group for Women Scotland, backed by prominent figures including J.K. Rowling, challenged the inclusion of trans women in that count. The court's ruling, unanimous and presented as clarifying the law, appears at first glance to offer legal certainty, but clarity for whom and at what cost, and that is the bigger question. I think one should be very clear that no trans organisations were permitted to join the litigation, and therefore the scrutiny on which the Supreme Court has based its judgment is highly flawed and biased. Transactual's chair, Helen Belcher, confirmed that trans voices were not invited into the courtroom, and retired Judge Victoria MacLeod, herself trans, was denied permission to intervene. One might ask, therefore, how can a case with such deep implications for a specific group be adjudicated without their presence? This is akin to delivering a landmark race ruling without hearing from any ethnic minority groups, or issuing a ruling on disability law without speaking to a single disabled person. The result is a judicial decision with the veneer of fairness, but with the process of exclusion. And therefore one needs to scrutinise the political climate into which this ruling has landed. Only months ago, the government itself ignored a Supreme Court ruling when it passed emergency legislation to push through its Rwanda asylum policy. Barely a year ago, admittedly under a different government, but, this is Britain. And the present government has not repealed that act, therefore has not, in fact, revoked the principle. The message, therefore, is clear. Some judgments can be discarded if they are considered inconvenient. So the Supreme Court is not actually supreme. And yet this ruling has been seized upon with breathtaking speed. British Transport Police have already changed their search policy. Public bodies are reviewing and rewriting guidelines, and the EHRC promises rapid guidance. All this with no consultation, no updated statutory code, no parliamentary scrutiny. Why the difference? Why is this ruling uniquely sacrosanct and the ruling about Rwanda is not? The answer, I fear, is ideological alignment. And when the government likes a ruling, it treats it as gospel. When it doesn't, it rewrites the rules. This isn't about legal consistency, it's about selective enforcement. The same sort of thing can be seen in parliamentary committees. When there was a review into reality TV, and only 4 reality TV participants were invited to give their testimony, and the committee was abandoned halfway through its process. It didn't stop the committee proposing or endorsing a ruling which gave huge power to Ofcom, and huge power to the producers of reality TV. Again, it's about selective enforcement and selective hearing. Contrary to breathless headlines, the court did not rule on the definition of a woman in general society, though. It ruled on a specific provision within the Equality Act. Paragraph 2 of that judgment makes this crystal clear. Nor did the court rule that trans people have no rights. Indeed, it reaffirmed that they remain protected under the Act, albeit under the characteristic of gender reassignment rather than sex. But the real confusion lies in that interpretation. Already some organisations interpret the ruling as carte blanche to exclude trans women entirely. Others cling to a narrow reading, hoping to preserve inclusion. In short, the ruling may be legally narrow, but its social implications are dangerously wide. And we're now seeing the fallout. Over 20,000 people marched through London yesterday, and protests erupted in over 30 cities. Their anger is not just about the legal language, it's about the signal this ruling sends. A community already vulnerable to violence and discrimination feels even more marginalised. The judgment has become a lightning rod. It's emboldened exclusion. It's emboldened the ideology of exclusion while terrifying trans people who once felt quietly protected by a system that, at minimum, acknowledges their identity. The fact that this case was brought by a small, well-funded group of Scottish activists, backed by crowd-funded litigation, adds to the suspicion. They were heard, but the trans people were not. The optics are hard to ignore. And this ruling cannot be the final word. Parliament must urgently review the Equality Act to clarify protections and address ambiguities introduced by this judgment. We need inclusive law, not judicial pronouncements that exclude entire communities from the room. Moreover, public bodies should not rush to reverse policy in a way that hardens exclusion. Proportionality and dignity remain vital legal tests. So the police, the Transport Police decision is wholly wrong. A blanket ban on access, driven by fear and ideology, is not what the court described. Proportionality and dignity remain vital legal tests. Finally, we should resist the weaponization of law to prosecute a culture war. The Supreme Court itself warned against this. Its judgment is already being spun for political gain. The same government that defied the court on Rwanda cannot now pretend to be its devoted disciple. This is not the end of the conversation. It's the beginning of a much-needed reckoning with how you legislate, how you listen, and how you define justice. Trans people are not a theoretical category. They are citizens, colleagues, neighbours, subjects, and they deserve to be heard when laws are made about them. To borrow from a protest sign, if your feminism excludes trans women, it's not feminism, it's discrimination. And I think we need to ensure that the next chapter includes everyone, and that everyone is present in the court hearings that define the way the law should be interpreted.